I'm warning you as a condition of your bond not to expose yourself to anyone in this county in public. Do you understand? If I find that you do, I will revoke your bond, put you in jail. No more PR bonds for you. Okay, Colin, can you hear me?
I can. Can you hear me?
Yeah, I got you.
Super.
So you're saying that there's a problem with the occupational?
No, there's no problem at all, Judge. I got him, and he has a 2-year suspension for an ALR. I got that. I got an occupational license for him in November. He pled to a DWI first in December, and then met with his probation officer in January. She's decided that she is a license guru and that his occupational license needs to be signed by you. There is no suspension coming from you, Your Honor. He's on
Right, I didn't suspend
probation.
it.
No, and all he has to do is the DWI education course, and there will be no suspension from you. So she has wasted his time, your time, the CLO's time, and I'm sorry for being here to even bother you. He has no other issues at all. He just started. He had to take time off work to come here and deal with this because she ordered him.
You didn't represent him on the initial case, did you?
No, Judge, I did not.
It was someone else.
It's George rule.
I remember.
They just want to make sure that occupational is appropriate.
There's absolutely no reason why you need to admonish him, Judge. He's on probation.
I'm not going to.
Conditions.
I won't.
I know.
I won't.
I appreciate it.
Do you want, what do you want me to run?
That
I'm
you
a no,
for him to use it, or I can just have him sign it.
and Judge, I don't want to waste your time or the CLO's time. If I can email her personally, and I will CC you and the CLO to let her know what you say about this.
Please include the state though, so it's not ex parte. Okay. Include the state for whatever though.
I'll include the state, but it is an ex parte situation, so I don't.
Yeah.
I mean, I guess it's
Okay.
probation,
I approved it, Colin. So.
Okay. I appreciate it, Judge.
Okay, man.
Hey,
He's here. Do you want me to let him go?
yeah, if we could.
Shatori's going to talk to him real quick.
Okay. Hey, I speak in dichos a lot too. So how do you say? ¿Cómo se dice stuck like Chuck?
In what? In Spanish?
Español.
I don't know. That's why we got translators, you know?
Good deal. All right, Judge.
Take care, man.
You too. Have a good weekend.
Judge, I know you told James Pond that you were going to give a PR bond to Alicia Rice, but she already received a GOB at Seaport. She's only being held on a motion for low parole. It's a whole
Then leave it. Then there's no need to do a PR bond. If she got a.
It's just a parole.
Right. Okay. No, you're right. Is James here or no?
He walked out before I could tell him.
Okay. All right, Ramona, you ready?
Yes, Judge.
Let's roll.
Bird on page 1 and 2. On page 1, sorry.
Courtney Bird, come up. Good morning, Mr. Frazier. Sir, you're charged with indecent exposure. You're facing up to 6 months in jail and/or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On March 1st, 2025, the officer was at a Texas Roadhouse parking lot in Harris County, Texas, conducting a traffic stop. While on the stop, 2 restaurant employees approached the officer to state the defendant had just exposed himself to them by having his car window down to be visible to them and stroke his up and down. The employees provided a picture of the vehicle, the license plate, and a picture of the defendant. While trying to get an accurate location of the vehicle, the defendant began approaching the employee while she was on foot in the parking lot. 2 employees pointed out the vehicle getting ready to leave the parking lot, and the officer conducted a traffic stop. The defendant stated he was trying to get to a hospital for a laceration to his left leg, and the officer went inside the restaurant to view surveillance of the parking lot. The officer observed the defendant waiting in the parking lot before the complainants walked out. The defendant was parked further back than the complainants. When the complainant got into their vehicle, the defendant drove forward and parked next to the complainants. The complainants turned and observed the defendant to have a passenger window down, sitting up in the driver's seat and stroking his penis in an up and down motion. The complainants drove off and came back to the defendant's vehicle to get a picture of the defendant and his vehicle. The defendant pulled forward again in a parking next to the vehicle with a woman facing away from the defendant. The defendant parked his vehicle and eventually drove away. The defendant drove around the parking lot and approached the complainant, who was on foot searching for him. The complainant ran away in fear of being hit by the defendant's vehicle.
Okay. Mr. Frazier, we're going to find that there's probable cause to go forward with the case. I'm warning you as a condition of your bond not to expose yourself to anyone in this county in public. Do you understand? If I find that you do, I will revoke your bond, put you in jail. No more PR bonds for you. I'm also ordering you not to go back to this place. Where was this?
A Texas Roadhouse, Your Honor.
Okay, you're not allowed to go back to this Texas Roadhouse. Do you understand? Likewise, if I find that you go back, then I will revoke your bond. So would you reach out to them to let them know that we have put these conditions in place?
Yes,
so that if they should see him again?
Yes, Judge.
Okay. Mr. Frazier, do you have the ability to hire a lawyer, or would you like to apply for a court-appointed lawyer? Okay. Deputy Miranda's going to give you an application. I need you to fill it out and I'll take a look at it. Don't be a danger to my community. Do you understand? Okay. Can you file those conditions? Oh,
Yes, Judge.
no weapons as well.
Yes, Judge.
Mr. Frazier, you're not to be in possession of any weapons as well.
Greg, can I get that call?
Yeah, it's 2530952. You are Ms. Borroquez.
Yes.
Ma'am, you're charged with possession of a controlled substance. You're facing up to a year in jail and or a $4,000 fine. You had court on October 2nd of last year. We issued a warrant for your failure to appear. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge.
Please.
On September 25th, 2024, the officer conducted a traffic stop on East Sam Houston Parkway in Harris County, Texas, after observing the defendant driving 70 miles per hour in a 50 mile per hour zone. The officer requested to consent to search the vehicle, and the defendant consented. The officer found a ball of white capital labeled tramadol on the front passenger seat. The defendant told the officer she did not have a prescription.
Okay. Ma'am, I'm going to find that there's sufficient probable cause to go forward with the case. Can you run your license?
Yes, Judge.
The only issue I have with the case is what's the reason for the search? I mean, she's nothing.
She agreed to it. I mean, that's.
I understand.
Her license is eligible.
Okay, as long as you have a valid Texas driver license and liability insurance, you may continue to drive. I am ordering you not to consume alcohol or illegal drugs or unprescribed controlled medication. If I find that you're consuming any kind of illegal pills that are not prescribed, I will put you in jail. Do you understand?
I understand.
You missed court. I'm going to give you a get out of jail free card today, but you're not going to get another one. You miss court again. It's really not going to go well for you. I will revoke your bond and put you in custody. Do you understand?
Yes, sir.
No more PR bonds. You pick up a new case, violate conditions, don't stay in touch with them. That's it. I'm not asking for much.
Judge, reinstatement?
Yeah, we'll reinstate the bond now. I'll leave it at 2501. Get ready because you will be tested. Do you understand?
Yes.
Okay. So,
For the record, it was for her mom.
well,
But yeah, we got to, yeah. So
just get it and you guys do what you need to do. I want to make sure that she's just not using. You know, the problem is, and what a lot of people don't understand is they go out, they party, they take these pills. Nowadays, you have no idea what you're taking. Just not even like a little bit of fentanyl kills you. You know, you take oxy, take too much, you put your lungs to sleep, you die. So you got to be careful. I don't know whose. I'm just be careful. That's it. You got but one life. All right. We'll have you sign a reset with Ramona, get you Felicia for your bond condition, Felicia, and then you're free to go.
Thanks, Judge. Have a good weekend.
Thanks, Rand.
Thanks, Ed.
Okay, so it's a DWI Class B. Mr. Pons, please.
Yes, Judge. On March 2nd, 2025, the officer was dispatched to an accident call on the 4500 block of Southwest Freeway. The defendant was passed out in the passenger seat of a tow truck, and the officer noticed that her eyes were low, her speech was slurred, her breath smelled like alcohol, and she had urinated on herself. The defendant stated she had one drink and was coming from a club. The defendant showed lethargic behavior, and the defendant confirmed that she was the driver and that no one was with her. Standard field sobriety tests were administered. HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 3 out of 4. The defendant consented to breath, and the results were 0.128 and 0.118.
We have her in the passenger seat of a tow truck.
Right. So her statement alone isn't sufficient. That's all they have about her driving.
And Your Honor, in the complete OR, there's further statements that kind of clarify the time period that when this happened. The officer stated that at 7:20 a.m., that's when he was dispatched to the accident call, and he arrived at 7:21. And the defendant stated that she was on scene and she was coming from her residence from a bar called Good Mood that she had arrived at 3 a.m. And the defendant stated she had the one mixed drink only and left Good Mood Lounge at 5 a.m. when she proceeded to head home. And the officer found the vehicle on the right shoulder stalled with the front passenger tire blown out. So the traffic or the encounter with the defendant took place 2 hours according after when she left the bar.
But none of that same. Well, go ahead. Calm down, too.
So do we have an officer that actually sees her in the car in the ditch?
No, Your Honor. The car is just found in the ditch with the tire blown out. And the only thing the officers have to put her in the vehicle is her statement saying she drove and when she left the bar.
Well, that's it then. If that's the only thing they have, no PC.
Why?
Their statement alone can't be sufficient evidence. They need corroboration.
And the corroboration we have is that when the officers arrived, there was nobody else on the scene. There was a crowded freeway. There was nobody else who could have gone to the accident or left the accident because they were on a highway with traffic and there were no other people around.
One, I don't see that the officer said any of that. Two, that's still not going to corroborate that she was driving.
Why are you saying that the statement, her statement in and of itself is insufficient?
That's a rule. I couldn't give you a case if you want.
Yeah. I do.
Okay, well, give
So,
me time.
Yeah. And I'm willing to, if you want, maybe like we can revisit on Monday
Okay.
because I want to give you time. I want to
Wait for her appearance for Monday.
Yeah. I'm going to put her under conditions though, but yeah.
Understood.
Okay. But I'd like to do a deeper dive on the PC and I want to know, is that in and of itself insufficient? And it'll give you more time as well.
I'll reach out to the officer.
Let's reach out Monday and we'll do more, I guess, a formal hearing. Ms. Poor, we will have an additional hearing on Monday to determine whether there's sufficient probable cause to go forward. So you need to stay in contact with Mr. Pons and he will tell you how we went forward on Monday. As it stands now, I'm ordering you not to consume alcohol or illegal drugs while you're on bond in this case. Do you understand? If I find that you consume alcohol or illegal drugs, I'm going to revoke your bond. I will put you in jail. Could you guys run her license, please? And any other prior DWIs?
Your Honor. No prior DWIs, and we're running her license right now.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you do not have car insurance, you are not allowed to drive. Do you understand?
Okay. Your Honor.
Great. So for now, I'm going to have you sign a reset with Ramona. We're going to set it for Monday. You don't have to be here. No. We're going to waive your appearance, but Mr. Pons will let you know how everything transpires on Monday. And then after you sign a reset, I'll have you meet with Felicia for your bond conditions. And after that, you'll be free to go. Okay? Okay, Mr. Pons. Thanks.
Okay, thanks.
See you Monday.
So she needs to meet for bond conditions.
Yeah, she needs to sign a reset, but yeah.
All conditions from Fraser, Judge.
I need her.
Good morning, Ms. Rice.
Good morning.
Ma'am, you're charged with failure to identify oneself while being a fugitive from justice. That makes it a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement. They're offering you 24 days in jail with credit for the 8 days that you've done. You need to understand there's a couple very serious points now. Number one, this is going to go on your record. It will be there forever. From now on, you're facing a minimum of 90 days in jail for any new cases that you pick up. The other thing that you also need to understand is that you're on parole. It's very possible that because you're on parole, by pleading guilty to this, it may result in further confinement. I don't know for sure. They may send you to ISF, but they really could send you back to prison because of this.
Yes, sir.
Knowing this, do you still want to do this?
Yes, sir.
You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it will go on your record. You can never take it off.
Yes, sir.
And how do you plead to the offense, man?
Yeah.
I'll find you guilty, send you to the agreement. Good luck to you. Thank you, Mr. Pons.
Ms. Ford for Raymond.